please you, my Lord Chief Justice, the statistics that we have for the opening of the Hilary term indicate that we have a total of 574 cases to be dealt with during the course of this term. Of that number, my Lord Chief Justice, 479 matters have been traversed. There is one new committal for the opening and a total of 66 new committals which were added for the term. There are 28 cases that are not yet sentenced. Now, of the 479 matters which have been traversed, the largest portion is occupied by the offense of murder, which accounts for 264, while the second largest portion is accounted for by the sexual offenses, which amount to 157. Of those 157 sexual offenses, I would indicate that 98 are for the offense of rape, while 35 are for the offense of sexual intercourse with a person under the age of 16. At the opening of this Hilary term, my Lord, I would wish to indicate that certainly we at the Office of the DPP stand with pride at what has been achieved, certainly during the sitting of the last term, and notwithstanding the COVID-19 pandemic, which now seems to have firmly entrenched itself as a backdrop against which we must view every endeavor of life, it seems. We take pride in the fact that trials have been taking place and that cooperation continues among all the various sides. And as we embark upon a new phase of the journey, we certainly pledge to continue the highest level of cooperation, and we take the opportunity to encourage the witnesses to come forward and make themselves available so that trials indeed can take place. May it so please you, my Lord Chief Justice.
Thank you, Mrs. Millwood-Moore. Mr. Williams.
I dare say, my Lord, I believe that I suspect that your efforts are in some measure taking hold. I know that there is a way to go, and we are entering the third year of this pandemic. I'd love to be able to say that we're getting used to it and that we're learning to cope with it more. But I know, my Lord, that the pandemic has had its twists and turns. New variants raise their ugly heads from time to time. And I know that my Lord Chief has grappled with the issue as to whether or not vaccinations should be addressed, if I might put it that way, by your Lordship. I recall in another forum, my Lord, and I hope your Lordship will forgive me for having quoted from Edward Morgan Forster, "Fools rush in where angels fear to tread," to say that this court ought not to step in that direction, given the vagaries and the fact that this is the Supreme Court. Your Lordship would be put in an invidious position down the road to have to deal with that very issue, having taken certain steps in that regard. But if I might say, my Lord, that the Bar Association pledges its support for criminal case management.
Your Lordship would be put in an invidious
Continues
position
its advocacy
down the
for
road to have to
financial
deal with
support
that very issue,
for the court system,
having taken certain
inclusive
steps in that.
of the physical infrastructure, provision for technology, and I dare say the staff. Also, remuneration for the current and retired judges and the need for adherence to the 9th Independent Commission on Judicial Emoluments remains topical for the Bar Association. We look forward to the smooth functioning of technology for Zoom hearings and trust that there will be increased cooperation between the police and the court for the smooth and timely commencement of trials. I know that this is a word that is not always liked, but the backlog, as we call it, the backlog of cases might seem in some respects to be staggering, even more so given the time and resources now devoted to a particular trial, Klansman gang trial, that is taking up so much of judicial time and space. Advocacy, we recognize, will have to be more efficient in its delivery, without compromising counsel's duty to his or her client to provide the best representation in the presentation of cases. I pause here to say, my Lord, and this is a word to my learned friends, that the best cross-examination need not be the most lengthy one. Effective cross-examination will take into account what it is you are trying to show the court, given the background of the evidence that is already before the court. Much will also depend on the expected efficiency of the court staff and the criminal registry, whose time and effort is to be acknowledged, but must recognize the need for extraordinary effort. Extraordinary effort, in short, is required of all participants in the delivery of justice in our criminal courts, whilst we battle with limited resources during a time of a pandemic which has affected jury trials in a significant way. We applaud the return of jury trials. The court, if it pleases your lordship, is where the advocate makes his or her bread and butter. It is our workplace, and we must jealously protect, preserve, and improve upon our workplace. So the Bar Association, on behalf of the bar in its entirety, pledges itself to do all that it can to preserve, protect, and improve. May it so please you, my Lord.
Thank you very much, Mr. Williams. Let me say a pleasant new year to all who are present, to members of the bar, the Office of the Director of Public Prosecutions, other persons within the public sector who interface with the courts from the different departments, not necessarily from the DPP's office. We have the Attorney General's chambers, we have MOCA, we have FID. Also say welcome to members of the press, both who are here in court and viewing online, members of the court staff, the police, and all the stakeholders. 2022 promises to be another trying year as far as managing the legal system in the context of the COVID-19 pandemic. And I think, certainly speaking for myself now, I think the time, certainly I am at the space in my mind where I accept that it will be here for an indefinite future period. Now, that has a number of implications for the operations of the courts. And I suppose I'll begin where Mr. Williams ended. This is with a question of jury trials. Now, there was a two meetings yesterday among the judges and also the relevant stakeholders in the COVID-19 Advisory Committee, which was held after the meeting of the judges of the Supreme Court. And a number of issues arose, and the intense discussion both among the judges and among the members of that stakeholder group, the COVID-19 Advisory Committee. The critical question was, how do we manage the jury trials in the context of the reported increase in the positivity rate and the acknowledged high transmissibility of Omicron, which has been confirmed to be present in Jamaica. And it appeared that the overall consensus was that the jury trials would be delayed a bit for another 3 weeks, it was suggested. And in that time, all the relevant stakeholders would be continuing to give intense thought as to the practical way in which jury trials can resume. So in our courts, they vary in size and configuration. And so it may be that jury trials will be easier to resume in some courts than in other courts. And so a lot of intense analysis would have to be done again to determine which courts resume jury trials and which courts may not be able to resume jury trials, because the question of the jury is not just the actual trial itself, but the underpinning administrative activities, such as the summoning of the jurors and having them gather in what I would call acceptable circumstances. Because unfortunately, our courts, many of our courts, at the time they were constructed, did not have adequate space for jurors to gather. They would usually sit in the courtroom. But now with the pandemic, and as a court, we must endeavor to abide by the guidelines from the Ministry of Health and Wellness. Some of our courtrooms are very small. So if you are to have the physical distancing, even just for the impaneling process, we would be in violation of the Ministry of Health and Wellness's guidelines. So the question now, as a result of the provision of tents, on the grounds of those courts where you don't have the space inside for the jurors to gather, and then when the time for deliberation arrives, where would they go? And so some of the thoughts have been, well, having them remain in the courtroom and all the other parties leave the courtroom to allow them the privacy to deliberate. Now, some of our courtrooms, they have no provision, for example, of a room for counsel. So normally counsel would remain inside the courtroom while the jury would go off to the room to deliberate. But if we're going to remain in the courtroom, then both counsel for the Crown and the defense, they might have to go either sitting in their vehicles or wandering around the court property until the jury returns. And so this brings into question now the whole question of design and construction of our courtrooms going forward. I know that it has been the desire of the Ministry of Justice to use the words of the minister, to have first-class buildings to complement first-class delivery of legal services. And so what is going to be required then is a whole different way in which we design and configure our courtrooms to reflect modern realities and convenience, because we need to regard it now as, explicitly as the workspace for counsel, because those attorneys were advocates. They spend a significant part of their professional lives in the courts. And so modern courtrooms should have a space where advocates can wait while they're having the matter heard. They should have interview rooms, because in some instances, especially for the attorneys who are practicing in rural Jamaica, in criminal matters, if the client is on remand, they're usually kept in Kingston. And sometimes the first opportunity to see them is when they are transported to the particular parish. And then the facilities are not ideal within the police stations to have the necessary consultation and preserving legal professional privilege, or at least minimizing the risk of legal professional privilege being violated with the discussions being overheard by persons. So all of those things have come to the fore, and that is why we, the judiciary, have had an infrastructure committee comprising judges and the Ministry of Justice, and we have come up with designs for modern courthouses. But of course, the critical question is funding. There is suggestion now of public-private sector partnership, and we had a presentation from the Ministry of Finance as to how it is possible, because our concern was, at the end of the day, the independence of the judiciary must not be compromised in any way. So those are some of the things that have been going on with regard to courtroom construction, which has been brought to the fore because of the pandemic. So we have now had to begin to think more about things that we hadn't thought about before. As far as jury trials are concerned, again, I think the time has come now to revisit whether we should retain jury trials, because I remember when I spoke at the Assize service in Montego Bay in 2019, and I indicated, who knows when jury trials will resume? Well, we are now in February of 2022, January of 2022. No, it was the Assize service in 2020. Yes, 2020. So here we are now. We are just roughly 2 months away from the pandemic arriving on our shores, and we have not been able to resume jury trials. And the variance and the fluctuation in positivity rate in the context of low vaccination rates in Jamaica, all of these factors combine to make jury trials very difficult to contemplate and to manage. And so it seems to me that the time has come now to do away with jury trials. Because the truth is that there's nothing to suggest that jury trials are an inherent better quality of justice than bench trials. There's nothing, no evidence to suggest that. And in Jamaica, we don't seem to have a coherent policy regarding what matters are tried by the jury and what matters are not. So if one looks at the law reports from the 1950s coming up, what you will notice over time is a policy of transferring matters from jury to bench trials. So when you look in the reports in the 1960s, burglaries, robberies, housebreaking, all of those were tried by juries. It's still possible now, but there can't be many lawyers alive today outside of the gun court context that can remember a burglary, a housebreaking, a robbery being tried by judge and jury. It hardly happens. Usually now it is in the context of the use of a firearm, and that is a bench trial. When we create new offenses within recent times, bench trials. So we had the lotto scamming, bench trials. Have the human trafficking that began life as a judge and jury trial. It is now a bench trial. So what is the policy that informs that? There was a time when cocaine cases were tried by judge and jury. It doesn't happen anymore. So money laundering, again, it's possible, but it doesn't happen. So what you will have is a situation in which, as far as criminal offenses are concerned, it's a declining list of cases that are tried by judge and jury. We now have the gun court that has been in existence for just over 40 years. And the only gun offense, firearm offense that's tried by a jury is murder. There's no other firearm offense that is tried by judge and jury. So it begs the question then, what is the policy and the thinking behind retaining jury trials in an ever-decreasing number of criminal offenses? And those criminal offenses tend to be murder, sexual offenses, woundings, and death in the context of vehicular collisions. And that's about it. If one looks at the data, since we started keeping reliable and accurate data in 2016, on the criminal side, both in the Supreme Court and at the parish court, exclusively bench trials, where incidentally the majority of criminal cases are disposed of. You will see that the greatest gains in terms of productivity have been realized in courts where there are bench trials. So that is why we are now at the point where over 92% of criminal cases in the parish courts are disposed of within our time standard of 24 months. That is what the data is telling us after 5 years of keeping reliable and accurate data. It is not surprising that the gun court here in Kingston is now operating at international standards. What does that mean? It means that, according to a statistician, where you have 10% or less of your total cases are in backlog, and a net backlog is 5% of your active cases or less in backlog. that is regarded as acceptable globally. So the gun court now is officially free of backlog. And one doesn't have to take it from me, speak to the attorneys. The attorneys will tell you that we are now trying cases that originated in 2021. And cases have been moving from arrest, being placed before the court, and disposition now in a matter of weeks, which incidentally was how the gun court was intended to operate when it was brought into being in the 1970s. So we are now realizing what the Parliament intended back then. So there is no magic in a jury trial. The question ultimately is whether there was a fair trial, and the fairness is assessed now in light of the procedural steps leading up to the actual trial and what happens during the actual trial process. That is really how fairness is determined, not necessarily by the mode of trial. And where we are now is that because we are unable to have jury trials, the cases are being pushed further and further and further back. And it is just a matter of time before someone is going to make the claim that their constitutional rights to a fair trial within a reasonable time are being violated. So the executive and the legislature really need to revisit this question of jury trials, and if we are going to retain them, then we have to have all the financial resources and material resources necessary to make it work in the context of a pandemic, because it is going to be costly. So that is what I would have to say on jury trials there. Now, Mr. Williams had mentioned the criminal case management. I am pleased to say that the Rules Committee of the Supreme Court will be taking up the question of criminal case management rules. A significant work had gone into it a few years ago, and a draft was developed about 2 years ago. But the committee was working on the rules relating to the proceeds of crime legislation for both the Supreme Court and the Parish Court, and that was quite extensive. I wish to express my gratitude to members of the Rules Committee, because there's quite a lot of work, meeting on weekends. When a draft was developed, persons give up their weekends 2 years ago. Practitioners, both at the public bar and the private committee, was working, and there's no remuneration involved. It's essentially relating to love and commitment. So those rules are finally here with us. Both the Supreme Court being completed now. Parish Court looking at that was quite extensive. I wish to criminal case management to members of the Rules Committee. And that brings me now to another meeting on weekends. Important when the draft was the persons give up their weekends 2 years ago. That is the public composition was working, and there's no remuneration involved. It's essentially relating to love and commitment. So those rules are finally the composition needs to be completed now. Parish Court looking to reflect. I wish to criminal case management to members of the Rules Committee. And that brings me now to another meeting on weekends. Important when the draft was the persons give up their weekends 2 years ago. That is the public composition was working, and being for rules is essentially relating to statutes and laws. Those rules are finally procedural needs to be completed. For example, prosecution rights of offences which the criminal model reality. Unfortunately, at this point, and that brings me now to another meeting on weekends. Composition of the rules committee give up the director of public prosecution. Composition include working of being director rules related to statutes and those rules trying to reflect procedural needs to be revised. For example, prosecution rights of offences which the criminal model reality. Unfortunately, a director of public prosecution years gone by, composition of the rules committee give up the director of prosecution. Composition include work of being director rules related to statutes and cases rules statute procedural needs over time. For example, prosecution rights of offences criminal model reality. Unfortunately, a director responsibility years gone by, composition of the rules committee give up the composition include works to develop director rules related to statutes and cases rules statute procedural needs over time. For example, trafficking in persons, prosecution rights of offences criminal model reality. Years gone by, composition of the rules give us you have the now right of appeal. So when you look at what has happened over the last 20, 30 years in terms of the role and function of the Office of the Director of Public Prosecutions, and the time is appropriate for the composition of the Rules Committee to be revised. Now, this is not to say that we have not found ways of accommodating the views of the Director. So the Rules Committee may have subcommittees, and so in that way you incorporate the Director and other persons who can provide necessary information and expertise. So that is something that we'll be looking into this term, and hopefully it will be resolved sooner rather than later. The other point I wish to make here is in relation to the civil courts. I know it has been a tremendous difficulty that the bar and litigants have been having, that the time between filing and trial is just simply too long. That is without question. And so what have we been doing internally to address that? Well, we have heard about the judges being assigned to do the assessment of damages cases and simple negligence cases. So those judges will be assigned there for 3 years. What that translates to in practical terms is the beginning of the introduction of some degree of specialization and also a docket system where the cases are allocated to the judges and they won't be moved on to another judge, to be with that judge or that group of judges. So, and what that should result in is greater efficiency. Over time, the judges will become familiar with the cases, because what has happened each time is that each time it goes to another judge, especially if the case is a voluminous one, it just takes that amount of time for the judge to get up to speed, to be able to manage the case effectively. So we have also established the family division. We have 2 judges assigned there. So over time, all of the family-related cases will come out of HCV and go to those judges. And so essentially, we wanted to operate it in the way that the commercial court operates, where the cases are assigned and the judge manages it from beginning to end. Now that will quite likely require us to revisit one of the rules in the CPR which essentially indicates that the judge who does the case management should not do the trial unless the parties consent. Now, I suspect that that rule was put in to deal with, minimize the question of prejudging and bias and those things. But again, while the intention is good, it is contributing more to inefficiency than to efficiency. And to me, the test of this is in the commercial court. The commercial division has been around now at least probably nearly a decade now, if not more. And the question that has arisen in my mind is there any evidence, as reflected in the number of appeals, to show that the judges in the commercial court are biased, given that the cases are assigned to them and they take the case from beginning right through to the end, and those cases tend to have multiple applications between filing and final disposition. So I haven't seen any case from the commercial court in which it is argued that because the judge did the case management, somehow the judge is incapable of adjudicating at the trial impartially. So sometimes we put in rules, maybe with good intention, but we have to look at how they play out on the ground. And so what has tended to happen is that when Judge A deals with the case of case management, you become familiar with the case, it moves on to another judge, and so delays the disposition of the cases. We'll also be looking at question of training of judges now for more effective case management. We have slated three 3-hour sessions. We have had 2 in the last term and 1 more to come up. And essentially what it is about is reinforcing to all of us that case management is not a perfunctory exercise. One of its objectives is to narrow the issues to what is really in dispute between the parties. Manage the evidence that is going to be coming in and deployed by the parties, and also seeking actively to resolve either issues or the entire case. And so one of the things that came out in the case management training is to encourage judges and the parties to identify the 1 or 2 issues that, if resolved, the rest of the case is resolved. Because oftentimes a case will have major issues, minor issues. It doesn't mean that every single thing has to be resolved for substantial justice to be done between the parties. So it is really now engaging the judges, engaging the parties to focus their minds on what is that critical thing, critical issue that needs to be resolved. And at the end of each case management, you measure success now in terms of have the issues been narrowed, because it is rare that every single issue is in dispute in a civil matter. Very, very rare. Possible, but rare. And so that is how we're encouraging the parties now to begin to engage the case management process so that we can realize what was intended. Because one of the interesting things that we learned was that the expectation was that with effective case management, only 10% of cases filed should go to trial. That is what came out during that process. Now, one of the issues that has affected the case management process is the file readiness, because oftentimes, as counsel will indicate, they come before the judge doesn't have the file, or the judge has an incomplete file. Not all the documents are there, and that is an internal weakness on the part of the court. So how is that being addressed? Well, we now have the judicial case management system, referred to as JCMS, and for the first time in our legal history, we now have a case management system in terms of software now in the parish courts. So where we are now is that Hanover Family Court, Westmoreland Family Court, St. James Family Court, Trelawney Family Court, and the St. Elizabeth Parish Court are all on the JCMS system as a very significant development in the life of our judiciary. And so it's a web-based system, and over time, as we improve our knowledge and understanding of it, we will get to the point where we'll have electronic filing. We are not yet there because, as you can imagine, it's still new to the staff, so we don't want to overwhelm them with having to do too many things, too many new things. So we have to introduce it gradually, and as their comfort level and proficiency increase, then we can take advantage of the other capabilities of it, because where we are heading to with that is ultimately electronic transfer of files between courts. So reduce the reliance on paper. Now, we'll still require a paper file in the event that a natural disaster comes along, because we are still in an earthquake zone and we're in a hurricane-prone area, and you can have those kinds of disruptions, but the courts must still be able to function. But where we are heading now is that the electronic file will be the main file that is utilized by the courts. What that means as we go forward is that calendars, lists and so on will be available electronically. So litigants, attorneys will no longer have to be calling the court's offices or the registry to find out when their matter is. It will be published as a matter of course. So that was phase one now. As I said, Hanover Family Court, Westmoreland Family Court, St. James Family Court, Trelawney Family Court, and the St. Elizabeth Parish Court are all on the JCMS system. For this term, the courts that are on it, you have the Gun Court here in Kingston, Criminal Registry here in Kingston, the Court of Appeal, the Revenue Court, and the St. Mary Parish Court. So all of those courts, so the Court of Appeal is now operating on the JCMS. Criminal Registry now operating on the JCMS. The Revenue Court now operating the JCMS. So too the Gun Court and the St. Mary Parish Court. In the next phase, we expect these other courts to come on stream: Trelawney, Portland, Manchester, Chapelton, and this is Manchester, both family and parish courts, St. Anne Family Court, St. Thomas, and St. Anne and Westmoreland Parish Courts. So by the end of April, we expect these other courts to be on the JCMS, so that by mid-year, we would have at least half the courts, if not more, on the JCMS system. In the next phase, which takes us from May to July, it will be Brownstown, St. James, Clarendon, Hanover. And certainly by September of this year, it is expected that the High Court Civil, Matrimonial Division, the Estate Division, and the Western Regional Registry will be on the JCMS. So we are heading in the right direction. And as I said, this should bring about significant efficiency is also going to involve a cultural shift for all concerned. So this is not going to involve no training on the part of judges in the Supreme Court, the Court of Appeal, gradually making the shift to working in an electronic space. Because putting in the technology is one thing, but having no person to make the transition in their mind, and oftentimes the changes is resisted because it now requires new thinking, new skills, new ways of doing, and all of that involves a learning curve. And sometimes we tend to become frustrated with the learning curve, and we go back to what we are used to. But I encourage all my colleagues and members of the profession to embrace the change, because that is the way in which the world is moving. And for those of us who interface with commercial institutions, financial institutions now, they are forcing us there. And notwithstanding the fact that from time to time we have glitches in the technology, but I think most of us will agree that interfacing with the bank now is far easier than it was even 4 or 5 years ago. I mean, the downside of it is that most of us don't even know our bank managers anymore. So it has that downside to it. So it really reduces the personal contact. So that is where we are moving in terms of the JCMS. And then by December of 2022, corporate area criminal, corporate area civil, and the tax court, St. Catherine Parish Court, Kingston and St. Andrew Family Court, and the coroners and special coroners courts should be on the JCMS. So what I'm saying then is that by December 31, 2022, all being well, our entire court system should be on the JCMS. And that now will lay the foundation for continued improvement, continued efficiency, because we don't have to be dealing with it. We don't have to be looking as well at the question of payments. So when you're filing documents now, I know that attorneys still either go themselves or they send the bearer down to the stamp office. And there's no technological reason anymore for that to happen. And this has a particular impact on small firms, sole practitioners, because when you have a small firm or sole practitioner, if your bearer is out with a due illness, then the attorney has to go themselves. And to spend hours down there, not the best way to spend your productive time. So it's a question of efficiency, a question of productivity, and making life easier for the users of the court. So those are the steps that we are taking throughout 2022, and where we must get to the situation in which the police submit files electronically and they are transmitted from the police station, whether to the DPP's office or to the court office. And when it enters the court system now, the question of doing all the intermediate steps between point of entry and trial should be done in an electronic space. And again, this is going to require a cultural shift. So nothing to be afraid of. It's just a new way of doing some of the things that we have been doing, and an easier way, a faster way, a more efficient way. So those are just some of the changes that we'll be introducing in 2022 in order to make life easier and better for the users of the court. So for the jurors who are summoned, please keep listening to the radio for the announcement that will be coming out today through our communications unit. Let me again thank the members of the bar and the police for their cooperation. And there's a point that I must mention. For the trial that is going on, the persons on trial have arrived early, virtually every day save the 2 or 3 days. So what this shows is that it can be done. So what we want now is for that to become the standard now across all courts. And then we'll go a far way in reducing the backlog, because it would now mean more time is spent actually dealing with the cases rather than waiting on persons to come to courts. And we are also expecting greater utilization of technology, and we'll be pushing not just the JCMS in the courts now, but we hope to get to the point by December 2022 that all the intermediate steps between arrest, being placed before the court, and trial can be done remotely for persons on remand. And this is particularly important, for example, where persons are charged in rural circuits, but they're kept on remand in Kingston, but their attorneys are back in the rural parishes. So technologically, there is no reason why the attorney can't remain in their parish rather than traveling to Kingston or getting in or having the prisoner come down to have things like bail, disclosure, medical care, all of those things. Those things should be dealt with electronically. So that is where we're pushing to have the technology in all the courts, adequate speakers, microphones, screens, and the bandwidth. And that the bandwidth should improve because the Ministry of Science and Technology, they have allocated some funds through the Ministry of Justice for all the courts to have the broadband technology. And so certainly by the end of this year, all of that should be in place. And we shouldn't have any more, let me not say any more, reduced difficulty in terms of the connection with the court and the ability to conduct those hearings without the defendant being present. And it is an access to justice issue. And when all of that is done, it now means that rural practitioners, small practitioners, will be able to realize significant savings and utilize the time better. You can now remain in your chambers and perhaps go to 3-4 courts in a day electronically rather than traveling physically, because the travel around Kingston now is virtually impossible. There was a time when you could leave the Supreme Court, go to your chambers, and then come back. It's almost impossible now. So for all of those reasons, we are pushing ahead with the technology, and the expectation is that it should be result in increased benefit to our court users. And I have Mrs. Jared Fletcher, who is sitting in the back of the court there, our Director of Communication. So what she'll be doing from time to time is conducting surveys, because we have to get into the business of surveys from our court users, so we can hear back from them frequently, how are we doing? And whether we are meeting your needs, because there has been a shift now in the way that courts think of themselves. Not just an authoritative institution, do it my way and there's no other way. It's now a matter of engaging with stakeholders and say, how can we serve you better? What are the things that we need to improve upon to make your interaction with the court easier and faster. So those are my remarks for this morning. Thank you all very much. And may I wish for all of us here a better 2022, a safer 2022. And I am fully aware that a number of us are still hurting and grieving. We have lost family members, we have lost colleagues, and we have not been able to, shall I say, grieve appropriately, because I remarked yesterday during the meeting of the judges, attending funerals remotely is just so sterile. It's just that you're being given a lot of information about the person, but it's not quite the same as when you're there in person. And so some persons have not completed the grieving cycle and to begin the process of healing and recovery. So we hope that 2022 will see healing and better emotional and mental health. And I'm going to urge everyone here to have an exercise program. You know, the literature is telling us that we must not just link exercise with weight loss. Exercise is just good for you generally. So regardless of your girth and weight, exercise is a wonderful thing. So begin an exercise program. You don't have to go to the gym. The good thing is that YouTube has, goodness, innumerable videos now. And the times range from 4 minutes up to an hour and beyond. So really, no one has any reason not to have an exercise program. So if you have arthritis in the knees and your joints, there are exercise programs for that. There are what they call no jumping exercise. They have exercise for pregnant women. They have exercises for men over 60. So any age range and any disability that you are suffering from, there is an exercise program for you. Just search on YouTube and it will be found. And this is one way of maintaining not just good physical health, but good mental and emotional health as well. So if we take on these things, we'll be better able to cope with the stresses of 2022. So thank you all very much. And we can take the adjournment now.